Major breaking news out of the United States District Court for the District of Mississippi. A federal district court judge has just found that machine guns are protected arms under the Second Amendment, and that a criminal indictment for the mere possession of a machine gun is unconstitutional under our right to keep and bear arms. Let's get right into this right now. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the winner of the 2025 Gunnies Award for the top voice of the Second Amendment in America. Thank you for your support. I could not have done it without you and your support across the spectrum in the Second Amendment community. All right, folks, so we got to get a little geeky on this. Got to give you some reality check on sort of the good news, the bad news, and the ugly news associated with this case of United States versus Justin Bruen out of the United States District Court for the District of Mississippi, Southern District of Mississippi. This is a decision by a federal district court judge who's a trial court judge named Carlton Reeves, who has issued a 16-page decision saying that machine guns are protected arms under the Second Amendment. Well, we like the result in terms of the answer, but really it's a little bit more complicated than that. So let's just go down what you need to know about this case. I'm sure this is all over the internet and social media, and I need to tell you how to think about this and why. To begin with, let us keep in mind who the judge is. Judge Carlton Reeves is a judge who is terrible. Now, what I mean by that is this is the judge that has unequivocally stated repeatedly how much he really hates originalism, how he doesn't like the fact that judges are bound to the text and history of things like the Second Amendment. He does not like the Bruen methodology. He does not like the fact that he is being converted into a historian, which is not true, because the only history that's relevant to a Second Amendment case is legal history, which last I checked, which is what lawyers do and judges do. They go back in time and they find laws that become precedents, and then you apply old laws, old precedents to today's controversies and resolve them. That's what you do as a judge. And of course, the Constitution, including the Second Amendment, is the ultimate legal history. You don't need a historian to apply the Second Amendment. You simply need lawyers that do their job by researching legal history, legal precedents, and applying it to today's controversy. It's not rocket science. Nevertheless, Judge Carlton Reeves has been repeatedly attacking Bruen. He was even quoted in the past by sources like CNN, and we've covered his antics before. So he's the one that wrote this opinion. So that backstory is important because of some of the things he says and does here. Because in some ways he writes his opinion out of spite and is very sloppy in his reasoning as he does it. So now that we've discussed the judge, let's talk about this case. The ruling in this case was that machine guns are protected arms under the Second Amendment, and that an indictment, a federal indictment of Justin Bruen for merely possessing a machine gun in his home was a federal crime, punishable by many years in prison potentially. So he was indicted, and his defense lawyers moved to dismiss on Second Amendment grounds, and Judge Reeves granted the motion to dismiss the indictment. This opinion has no binding nature outside of the context of this case. There's no injunction. There's nothing that applies to any other American. Specifically, it only applies to Justin Bruen. Now, I should note this. Based on the court's opinion, which I'll put a link to down below in the description of this case, or the description of this video, I should say, Justin Bruen seems to be an upstanding citizen. No criminal record, nothing. In fact, his record and sort of lawfulness, if you will, was so clear that when they arraigned him and he pled not guilty, they let him go on his own recognizance. There was no real restrictions on travel, no bond, nothing. So that only occurs if the government and the court basically thinks the individual is not a threat to anyone. So there's no indication that the defendant here is a danger to anyone or has ever even committed a crime. Nevertheless, he's been indicted for a crime that could put him in prison for many years for the mere possession of a machine gun. Now, with that said, that's the first thing. Bad judge, good defendant. Now what? So what should happen now with the Trump administration? Then we're going to break down this opinion. So if I were the Trump administration running the Department of Justice, I would drop this case. I would drop this case for several reasons. The first one is the defendant here, given the fact that he has got no criminal record and no evidence of dangerousness, I would exercise my discretion and be like, why are we messing with this guy? Tell him to turn over the so-called machine gun, be done with it and say, look, you lost your machine gun. We're not going to criminally indict. Don't do it again, and move on. Don't waste resources on a case like this. It's nonsense. That's the first thing. The second thing is, I don't think anything good can come out of this, because the reality is, folks, and you're not going to want to hear this, but again, you turn into my channel not to hear rainbows and unicorns, but to hear the reality of what's going on in the court system today. The reality is we have at most 3 votes on the Supreme Court, maybe not even that, to say that machine guns are protected arms under the Second Amendment. We might only have 1 or 2 votes who would say that. So we're never going to win, at least not in the short term, the argument that machine guns are protected under the Second Amendment at the U.S. Supreme Court. We're still struggling to get the U.S. Supreme Court to hear a case saying that semi-automatic rifles are protected arms under the Second Amendment, even though they undeniably are, and that magazines that hold more than 10 rounds are clearly protected arms under the Second Amendment. They undeniably are. But we need the Supreme Court to actually say the obvious, and they haven't done that yet. So if we're having problems getting the court to say that, we're certainly never going to get them to say that machine guns are protected arms under the Second Amendment, regardless of what we think and view the situation. That's just not going to happen. So if I were the Trump administration, I would drop this case. I'd let this precedent be as a district court and not seek an appeal to the U.S. Court of Appeals for the Fifth Circuit, because ultimately it's not going to prevail in any good way for the gun rights or the Second Amendment. So I would let it slide. Now, let's talk about this opinion specifically. Judge Reeves actually sort of got the methodology correct. And what do I mean by this? He did actually apply the historical principle that Heller set forth, the constitutional test that Heller set forth, which is this. Governments cannot ban an arm today if it is in common use by Americans for lawful purposes. And on a related note, sort of a corollary, the ultimate principle, of course, from which that in common use test is derived, is the notion that a government can ban arms. It can ban arms if those arms are dangerous and unusual. Dangerous and unusual. Now, here is where Judge Reeves got sloppy, and unnecessarily so, and played, in my view, a little bit of like malicious compliance with some language of Heller and Bruen. What do I mean by this? You see, Judge Reeves is in the District of Mississippi, the Southern District of Mississippi. This falls within the jurisdiction of the United States Court of Appeals for the Fifth Circuit. Why is that important? Because the U.S. Court of Appeals for the Fifth Circuit has already ruled in a case called Hollis that the federal law that bans the possession of machine guns is constitutional. And the Fifth Circuit already applied in that case of Hollis the dangerous and unusual standard, finding that machine guns were dangerous in many respects and unusual because there are only, listen carefully, there are only 175,000 or so of them in civilian hands as of 1986, when the so-called Hughes Amendment went into effect. Now, Judge Reeves knows this because on page 8 of his opinion in this U.S. versus Brown case, he specifically quotes Hollis versus Lynch. He specifically cites to the Fifth Circuit precedent that says that machine gun bans are constitutional under the Second Amendment, citing the binding law by the Fifth Circuit, which he is bound by as an inferior court to the Court of Appeals. He also literally cites and quotes in his opinion that there were only 176,000 machine guns in civilian hands as of 1986. And that number cannot go up because of the Hughes Amendment that says you cannot buy new machine guns if you're a civilian. Doesn't apply to FFLs, doesn't apply to the military, doesn't apply to law enforcement, and so on. We're talking about civilian firearm use here, civilian firearm possession of machine guns. Now, Judge Reeves knows this because he cites to this, but then he also goes on to say, and this is where he gets cute. He says, well, I am told by the U.S. Supreme Court in Bruen that I'm to rely upon the principle of party presentation. The principle of party presentation. Now, the principle of party presentation is just basic law. It says, look, if you're a judge, you're supposed to rely upon what the parties present to you in terms of evidence. Okay? But here's the thing. He takes this to an extreme that's not legally allowed. What do I mean by that? Party presentation is about let the parties present their cases to you. But when you're dealing with legal interpretations, what the law means, courts are allowed to look at legal precedents. Here, Judge Reeves is obviously allowed to read and study the U.S. Court of Appeals decision in Hollis versus Lynch, in which it says that the Fifth Circuit Court of Appeals finds that the only machine guns that existed in 1986, when the Hughes Amendment went into effect, was 176,000. Okay, he knows that. That is what is known as a legislative fact. It is a fact that is universally understood to be true. If a fact that is universally understood to be true exists, parties don't have to present that. You don't have to put on evidence of how gravity works. You see, you don't have to put on evidence that it rained on a certain day if everyone understood it rained on a certain day and there's no dispute about that, and that's in the government records, let's say. You don't have to say, for example, put in the evidence and prove that there was a terrorist attack on September 11th, 2001, because it's understood and not specific to the parties involved. Now, the reason why this is particularly important is because these are known as legislative facts, and they don't have to be presented to the court to be understood and used. So what happened here, and this is the game that Judge Reeves played, and you got to understand this background to understand what Judge Reeves did is play game here. He says, well, I can only accept documents and information presented by the parties. Now, this principle of party presentation is very important here because on page 7 of his opinion, Judge Reeves points out that the defendant's lawyers point out that there are 740,000 machine guns lawfully possessed in the United States in 2021. And that sounds about right. And therefore, Judge Reeves goes on to say that because there's over 700,000 machine guns in American life in 2021, that is more than in common use. That is clearly in common use, especially when you compare it to Caetano versus Massachusetts, the Supreme Court decision in 2016 that said that approximately 200,000 stun guns were basically in common use if you look at the concurrence by Justice Alito and Justice Thomas. So just Judge Carlton Reeves here says, well, 740,000 machine guns in 2021 in the United States is above the 200,000 in Caetano. It's obviously ubiquitous. It's obviously in common use. And therefore, machine guns are dangerous, but they're not unusual. They're in common use, and thus they cannot be banned. But here's the thing. Because the standard for in common use is use by law-abiding Americans for lawful purposes, civilians, if you will, the proper number to look at is the 176,000 number that Judge Reeves is well aware of in the Fifth Circuit decision of Hollis versus Lynch. Instead, he says, well, the defense lawyers presented the 740,000 number to me. They presented the 740,000 machine gun number to me. But the parties did not technically present to me the 176,000 number. But that's not entirely true because Judge Reeves points out that the government pointed out the Hollis versus Lynch case, which included that fact of the 176,000 machine guns that existed in 1986. So what happened was that Judge Reeves embrace the $740,000 number, which is not accurate because it's apples and oranges, because the 740,000 number of machine guns that was cited by the defendant here included not just the 176,000 machine guns owned by civilians as of 1986 when the Hughes Amendment went into effect and you couldn't buy new machine guns. That number also includes governments in the possession of machine guns in the possession of government, such as state police, law enforcement, FFLs, gun companies, and so on and so on. But those are not relevant to the question of do ordinary American law-abiding Americans commonly use these firearms for lawful purposes. So he's counting the wrong data to get to in common use, and thus to show these guns are not dangerous and unusual, instead of the 176,000 number, which is the correct number to apply. And it's the number that was applied by his senior superior court, the U.S. Court of Appeals for the Fifth Circuit, in the Hollis versus Lynch case. So not only is Judge Reeves here ignoring the legislative fact of the number of guns in civilian hands, meaning machine guns of 176,000, he's pretending that that's not the binding number, and he's pretending it's this other number, the 740,000 number, which is wrong. He also is basically ignoring this Hollis versus Lynch case. Now, he does say he's aware of the case. He goes on to basically say, hey, I don't have to follow it because that was before Bruen. As you know, in an arms ban case, the relevant case that applies is the Supreme Court's decision in Heller from 2008. And yet here you have Judge Reeves is trying to apply Bruen as if the Heller case doesn't exist. But he knows Heller exists because he's applying the dangerous and unusual test. So as you can see, this opinion is a mishmash of various legal reasoning and sloppy at the end of the day by Judge Reeves. And all this reveals at the end what he's trying to do, which is trying to discredit the Second Amendment and the Bruen methodology and bring back interest balancing. We know this because if you look at his concluding remarks, you can see his disdain for the Supreme Court and its Second Amendment jurisprudence and originalism. Here's what he writes. The age-old problem of judging is how to honor an individual's constitutional rights and respect the will of a democratically elected majority. We look to history to try and find a satisfying answer to that dilemma. But this court has its doubts that the historical approach wielded in these recent Second Amendment cases is the right one. Bruen specifically requires judges to follow history and tradition, evaluate whether new laws are relevantly similar to past laws, and determine whether certain firearms are dangerous and unusual. These tests are deeply concerning to many. They will continue to generate confused and confusing lower court precedent. Of course, that's silly, because all lawyers and judges do is effectively legal history. We don't care about what undergarments were worn in the Victorian era. No one cares. What we care about in the law in these Second Amendment cases, and the same with all legal cases, is what are the legal precedents of the past? Those are discovered by attorneys, right? And then those precedents are applied to modern controversies. It's not about airy-fairy history, and the fact that historians are upset that they don't get to play in the sandbox because they didn't go to law school is not my problem, nor is it the Supreme Court's problem. And the Supreme Court has made it clear that you don't need historians, which is what Judge Reeves thinks you do, and he said that in the past, because the number of historical experts testifying in Bruen, Heller, McDonald, Caetano, and Rahimi totals a grand number of 0. Judge Reeves doesn't like that. He wants to be able to call historians to the stand, have them testify about the meaning of the Second Amendment so they can testify and eviscerate the meaning, as opposed to doing basic legal work and interpreting the text of the Second Amendment and applying legal history, which is what lawyers do literally every day. So the bottom line is, I hope the Trump administration doesn't appeal this case. I see no upside to the Second Amendment. We are never going to win. I don't want to say never, but in the many, many years into the future, we are not going to get 5 votes on the Supreme Court to say that machine guns are protected arms. And I don't think there's any value in pursuing this line of argument. It's just the harsh reality. Now, with that said, what I might have argued as a lawyer for the defendant is this. I might have argued that the statute is actually in violation of Article 1 of the Constitution, and I might have argued that the Hughes Amendment is unconstitutional for the same reasons why then Judge Alito, now Justice Alito, argued in the Rybar case out of the Third Circuit that says that the Hughes Amendment, which bans you buy new machine guns, I might argue that's unconstitutional under the Article 1 of the Constitution because Congress lacks the authority to ban you from buying new machine guns because there is no connection to interstate commerce. So while perhaps machine guns may have to be regulated and registered under the National Firearms Act, and there's no Second Amendment problem with that, I do think there's a legitimate Article 1 problem that Congress exceeded its authority in enacting the Hughes Amendment, and that might be a better way to win cases like these machine gun possession cases that we just saw in U.S. versus Brown. As to what the Trump administration Department of Justice is going to do with this case, I don't know, but if it were me, I would be like, hey, this guy doesn't deserve to be harassed. He was a defendant. He's not violent. He's not dangerous. We lost. Let's move on and just not appeal and move forward. As to what they do, I don't control that. That's what I would recommend. If they came to me and asked me, that's what I would tell them. Simply drop it. It's not worth it. This guy is a perfectly normal guy based on all the records. He's not dangerous. He's not a criminal. Let it slide and don't risk getting a precedent that would hurt the Second Amendment in some way that we cannot predict right now. So there you have it, folks. Hope you learned something here today about this case. Make sure you follow me on X at @4boxes Diner. Don't forget to subscribe both at Rumble and on YouTube. And I look forward to talking to all of you again very, very soon here at the 4 Boxes Diner.
Orders up. Table 2A.